Greg Burt, Cabot, Danville, Peachum.
And then why don't we ask the rest of the folks in the room if they would say hello, just so we remember who they are or meet them for the first time.
Win Zagoff, the Vermont Forest Products Association.
Sidonia.
Oh, I'm Sidonia. I'm Pete Barthel. I'm tracking for the crafts and for no clients specifically today, just non-fiction.
Thank you.
I'm Mike Caribou. I worked with the previous committee that was in here and all the rest of the legislators to create H614 timber trespass.
All right. Great. We'll turn it over to you then.
Thank you, Chair. For the record, Todd Delos, I'm an Assistant Attorney General at Attorney General Charity Clark's office. And just for a little bit more context, I grew up in Glover, next door to loggers. So I have a little bit of working knowledge of some of the industry, but
Your name again?
Delos, Parent Hill Road. So I wanted to just walk the committee through the report. And I should say at the outset, the author of the report is Assistant Attorney General Megan Harris. She has been in front of this committee or the previous biennium committee, did a tremendous amount of work. And the reason I'm here is that she's also the lead prosecutor on a number of the cases involved here. And for the simplicity of what she knows and what she can say might cause a little consternation from questions. It's easier if somebody who has less confidential knowledge comes in. I have a good working knowledge of the report. I have a good working knowledge of the work she did, which was pretty significant, working with a lot of stakeholders. At the outset, what I'll say is that when you have a chance to look at the report, if you haven't yet, this is a surprisingly complex area of both the law and personal experience. Timber trespass, as we understand it, sounds simple in the most basic understanding, unlawfully cutting someone else's trees or cutting more than you were contracted to cut. The realities are cases that fall into the timber trespass category can include boundary line disputes. Was it my land? Was it your land that I have authorized to cut? Contract disputes. Exactly what did we say? What did we agree to? And a whole host of other potential civil claims and criminal offenses. And that's part of the reason that some of the numbers in this report, and I think a lot of the testimony this committee has heard in the past, create an understandable and conceivable perception that this is a widespread problem. And there's no reason to think that's not true. But the final result of this report and our conclusion is we do want to wait and see where things are since the passage of the Land Improvement Fraud Statute last biennium, and a request through this report to increase the amount of information sharing and a centralized focus so that the various different entities that hear reports of timber trespass or respond to reports of timber trespass have an ability to track and understand the scope and scale. We also believe that some of the most recent legal actions that our office has taken may have an impact on the amount of timber trespass occurring. That said, I don't want to in any way give the impression we think this is not an issue for the state. We certainly recognize that it's a significant issue, and it is the kind of issue that once a tree is cut, there is no replacement for what has happened to that landowner, certainly not likely in our lifetimes. So with that, and barring any preliminary questions, I will walk through the report. So the legislature in Act 153 requested 4 things out of this report: a summary of the current issues, a summary of the mechanisms and alternatives that other states use, other jurisdictions to enforce, our recommendations about how changes could occur, policy, program, staffing, budget, and then looking into seizure and forfeiture as a possible remedy in cases of timber trespass. The AG's office took on this work in part because of our enforcement role, but it's really important to recognize the sweep of other partners who are a major part of this. A lot of work with DFPR, Forest Parks and Rec. Public safety, of course, is involved in that. We also consulted with the Treasurer's Office around property and funding, state's attorneys who are the preliminary or primary prosecutors in cases of timber trespass, PLC, the Professional Logging Contractors, Vermont Forest Products Association. We also talked to DEC, Environmental Conservation, Fish and Wildlife, and the judiciary. So a lot of folks brought in. I can walk you through the numbers of meetings, the numbers of emails, but I think it is safe to say this was a fairly exhaustive and engaged process. And I think most of the stakeholders had ample opportunity to share their experience, and we certainly welcome continued engagement. As far as talking about the scope and scale of the problem, as I said, timber trespass is the wide end of the funnel, and I think there are a lot of different incidents that can fall into the category of timber trespass. Over the course of the research and putting this report together, in the last 10 years, we looked at about 73 different incidents that we considered potential timber trespass. And what I mean by that is incidents that came in either through the judiciary and filed cases or reports from sister agencies and the like that carried out some of the elements that we consider part of timber trespass. Of that, the AGO was specifically aware of 44. So 44 different incidents came through our office. And from those 44, the state in one form or another, either state's attorneys or the AG's office, acted on 20 enforcement actions, which included about 28 different incidents. And that gives you a sense of some of these cases, some of these enforcement actions involved multiple incidents of timber trespass, could involve multiple actions by a single party or a group of parties carrying out timber trespass or something we would allege to be timber trespass. Essentially, I can talk through a little bit about what timber trespass looks like for a landowner, but I think that's probably much more valuable hearing from landowners if that's the direction the committee chooses to go in. But again, a lot of the work in this space through our research suggested that many of these incidents occur not where someone cuts on, not where someone purporting to be a logger cuts onto someone else's property and cuts a whole bunch of trees, but actually it's usually a dialogue between landowner and logger, an offer to cut, a conversation around what's going to get cut, a conversation around how the profits could be shared from that logging operation, and then somewhere along the line, a breakdown, whether it was intentional or not, on the part of what gets cut, what was anticipated to be cut, and how much gets paid. The other really important element is how much cleanup occurs after. And I understand members of the committee had an opportunity to go see a logging site, even the best run logging sites, and I would defer to the members of the committee who have much more experience on this, are not pristine environments. But we recognize that in a lot of these instances of alleged timber trespass, there's a tremendous amount of damage done to the property of the landowner beyond the unlawful cutting of trees. So that's essentially the overview of the landscape generally. I want to talk about the legal responses. There are a number of different legal avenues here.
Representative Lipke.
Counselor, I don't want to, sorry to interrupt, but there's an awful lot of damage done. It is sort of a negative connotation. The aesthetics change, but every log job, there are proper closeout to protect or maybe leave the main skid roads better than they were found, water bar that make them resilient. So I just want to flag that
Damage.
Yeah, very certainly. It's changed and the aesthetics can be different.
And not to, I appreciate
Very
that.
respectful of you and your role and your agency. But I just want to point that out.
And not to veer too far out of the lane, but there's certain trees that actually propagate better with a certain amount of disruption to the soil.
And that scarification is critical for regeneration, natural seed regeneration. Too much, and depending on the slope, can have other impacts on soil sustainability or water quality.
I appreciate that, and I'm happy to amend.
Just because we're out there on YouTube.
Yeah. Absolutely.
To be clear.
I appreciate that. So as far as legal responses, there are a number of criminal penalties that potentially apply to incidents of timber trespass, and there are a number of civil penalties or claims that can be made as well. I can walk through them, but essentially they all revolve around either taking a parcel of realty, so that really just means the trees are part of the parcel of realty, actual timber trespass is a criminal violation and can be brought as a criminal violation. Criminal mischief is a lower level claim that can be made there. Transporting stolen trees is another criminal statute. And then on the civil side, so looking for damages and injunction as opposed to a criminal penalty, there is civil timber trespass, unlawful civil mischief, and consumer fraud, which actually, curiously, is the area. And I say that because it would provoke curiosity if it didn't work for the AG's office. That tends to be the area where we lean in the hardest, because that's where we see a deceptive practice, not an individual event, but a series of pattern of practice within commerce. So I'll get to those. Yeah.
Representative Nelson.
Yeah, thank you, Chairman. So consumer fraud would be someone comes in, cuts timber on your land and misrepresents how he sells that timber and what he receives for it to pay fair stumpage back to the landowner?
That could be. It could also be a pattern of saying, Representative Nelson, excuse me, I'm going to come to your property and I'm, going to cut X amount and I'm going to finish off the, use appropriate closeout practices and ensure that the site is returned to an appropriate quality. And then I overcut, I underprovide, and I don't clean up. And that happens in repeated cases.
Okay, all right. And how are we reaching out to landowners to let them know that this is there? Are the county foresters bringing it? And that there was an issue back home before this bill took place. And I was talking to people about it and trying to figure out, how to get ahead of the next one. I hadn't heard this bill had passed. Before I got this job, I didn't sit and watch YouTube videos all day long. So so how is the outreach?
It's a great question. I think that speaks to one of our recommendations, and I'm happy to touch on it. I think it's challenging for landowners to know exactly what to do when this happens. And that's part of the reason that understanding the overall landscape of timber trespass is somewhat difficult to get our arms entirely around. So are you looking to sue the logger based on the fact that your contract says one thing, but it appears they do another? Are you concerned about the environmental quality on the land? And so you talk to Department of Environmental Conservation. Do you have concerns over the county forester coming in and saying, hey, this is an unlawful clear cut or an unpermitted cut? So there are a number of different entry points, and precisely because of that, it's hard to understand, both for landowners to figure out how to respond to this, and for the AGO in this case to get our arms around exactly what the scope and scale of the issue is. What I would say for landowners in that circumstance is, as I was saying, there are a couple criminal avenues to take. So it really is figuring out who's going to investigate it. And it's part of the reason that these can be challenging cases, and then who's going to prosecute it. And I think in the current moment, I would say candidly, we all understand our state's attorney's offices are strapped for resources, that these are hard cases to bring. And when you're looking at violent crime and other things that are urgent, I think it is hard for state's attorneys with their current resources to prioritize these. That said, and part of the reason we get involved in some of them is when we see a pattern, we hear about an actor or a group of actors where there's a repeated concern around their commercial behavior, that's where the AG's office looks to step in to try and end those. An individual landowner, though, has also the ability to sue for damages in a case of timber trespass, but of course that requires them having an attorney and carrying that out. But you can kind of get a sense from that. I don't have a good mental visual on, there's one event that occurs, a lot of entry points into a system, and a lot of places where it can go out the other side. And I think what would be helpful from our perspective on this is really getting as many of those pulled together. So by way of example, when we talk about the number of enforcement actions or cases filed, we literally had to look at civil complaints in court. And if it wasn't a complaint for timber trespass, it's hard to say, did it end up in court as a boundary dispute? Did it end up in court as a contract action? Not specific to timber trespass. And that can be a choice that a litigant makes for a whole host of reasons. It's also a choice, for a prosecutor is, what case can you most accurately bring? What's going to be the most successful? To get out, to do the research around timber trespass, to prove up the case beyond a reasonable doubt can be a pretty high burden. And I don't speak to that from personal experience or even the experience of our office, but it is understandably a pretty big challenge for our prosecutors. That was a long-winded answer, but I hope it.
Well, I can understand someone doesn't clean up the job right, or someone overcuts by a percentage. If they make an illegal clear cut, I hope the landowner is held harmless and the onus is on the logger to pay the fines. When I think of timber trespass, I think of, guys logging here, and he looks over there and there's some beautiful cherry trees, and I'll just skin right in there and grab those 20 cherry trees and 5 pine and that veneer log maple, and I'm gonna pull them back across, they'll never know. And you find out. And you say it's hard for the prosecutors, or, you start cutting some of that high grade lumber. It's got real value to it. It's probably cheaper if they steal my pickup truck.
Yeah.
And I just worry that they're not putting a value to that person's timber and the real worth that it is. And I'm not talking about the leaves changing color. I'm talking about the stick value. It's real. So I have a concern about that.
Yeah, and I appreciate that. Yeah.
Just
Sorry.
more of a clarification, because other than myself and Chairman Durfee, everyone sitting here in this committee was not here in the last biennium in this committee. But for those of you here, just to be clear, this was brought up because the gentleman that's sitting in the room who was victim of criminal predatory practice and spent up to 7 years trying to seek restitution or justice. And his testimony and that of others was so disturbing. The body, and it came not from this committee originally, another representative from Marshfield, who was Mike's representative, brought this to my attention and others, and we felt that for our industry that this was a critical responsibility for our survival as a legitimate responsible logging community, that these victims need some protection and not go bankrupt trying to get judgments, and then there's no restitution ever or justice. So that's why we're here today. And in the end of the day, it passed pretty much unanimously in the House and the Senate. And the AG's office was asked or required in the bill to try to do research, outreach for possible avenues to protect future victims and from this kind of egregious criminal activity. And that's really what Counselor Todd is trying to report on, what they came up with. So I think, various organizations weighed in. I went with the previous Assistant Attorney General dealing with this case, Megan. 2 sides met offsite over the summer to try to get a handle on the sort of rulemaking or what they can do. So I'm taking up more airtime than I meant to, but I just would love to hear details. And then with respect to those requests that the legislation asks of the AG's office, and we might be able to discuss that.
Well, thank you. That was good summary background, Jed. And why don't we have Todd continue sharing what, highlights anyway, of what's in the report. And I'll just say, we'll hear from Todd. We'll have time for questions. We'll all be able to read the report then, on our own time. And then we may have either your office back or some of the stakeholders that were invited to participate in the process may have something to say too. So this doesn't need to be the only discussion.
Thank you, Chair, and I appreciate the background as well.
Thank you.
So I'm going to actually just cut ahead to there's more description here that I recommend you take a look at in terms of what the responding actions look like, also how the state is circumscribed in responding to some of the cases. And I do think it is telling that there are a relatively small number of private civil timber trespass cases. So that's in the incident you suggested, right? That other landowner who was damaged suing the logger or whomever cut the trees or was responsible for it for the damages available. And they are pretty extensive damages because of the value of the trees. But of course, unlike your pickup truck, you can't get another one. And that's really what we see that. Yeah.
Yeah.
So I think to summarize the landscape, there are a lot of ways in. There are a lot of individual agencies that can become involved in an incident of timber trespass. And that creates some of the confusion, some of the challenge for individuals looking for recourse. And we'll talk about at least the first recommendation in that space. The second request from the legislature beyond kind of the landscape was, what about other jurisdictions? What are other jurisdictions doing? There was some discussion with the stakeholders, but across the board, everyone said, look, Maine is doing it the right way. And so we focused this report on what Maine is doing. And Maine has a somewhat different statutory structure, but with the passage of land improvement fraud, Vermont is more in line, covering more of the field that Maine does. And our perception is that legally speaking, in terms of the statutes available for recourse, with the addition of land improvement fraud, most of the potential entry points, what actually happens on the ground, there is legal recourse for individuals within that space. The areas that Maine touches on that I think are worth considering, the first is increasing consequences for repeat violations. So when you have a repeat bad actor, Maine has a criminal statute that is an effective tool to deter that. It is yet to be seen, given how new land improvement fraud is, whether that helps support or deter, I should say, that kind of unlawful behavior. Beyond that, and these were reproaches the PLC recommended, and I think we endorse as well from our perspective. One is a ticketing system for trips. I think that by and large, so I don't know how in depth to go, and I certainly know how shallow I can go, but effectively it is a ticket system. So trees are cut, trees are hauled to a log landing, trees are picked up and hauled to a mill. A system that tracks the trees from point A to point B to point C, and ensuring that there is a record around where, how many, when, and where they went to. And again, my understanding is that in the industry, by and large, this is best practice and is already being done. But of course, there's a space there to respond to that. And then the other suggestion from Maine is advanced harvest notification. So some measure of informing more individuals that a harvest is going to occur, and that provides a little more transparency and a record of how big, where, and when a harvest is going to occur. Moving over to the third piece of the report are our actual recommendations to improve how we respond to timber trespass. I think improved enforcement across the board is what people pointed to as being one of the biggest challenges. And because of, again, the multiple entry points and a lack of clarity on what to do if this happens to you, we would really encourage some means of improved centralized tracking around these complaints and concerns. So whether someone calls the Department of Forest, Parks and Rec, or they call the Environmental Conservation, or make a report to local law enforcement, some means of bringing those reports together so that we begin to understand the scope and scale of the problem across the board, as opposed to looking at legal actions after the fact and trying to go back to build the case. And it took me a while to get this point, so I will just share it in case it helps others. Part of the reason that a case may not, even criminal, may not result in a timber trespass charge is if other behavior or other incidents occur surrounding that timber trespass. There's a fight, there's other theft, there are other charges that can be brought to an individual involved in a timber trespass that, from a prosecutorial standpoint, we're going to take somebody off the street or otherwise impose some kind of significant penalty. They're going to go for the charge that's provides the maximum support for the public safety in question. That's not to, I don't have any specific incidents of that, but we understand sometimes things shift in the course of a criminal prosecution in the same way they do in the case of a civil litigation. So really pushing for that centralized report resource, we feel like is a key step. Part of the reason we're not advocating for necessarily increased resources, whether it be game wardens or environmental enforcement officers, is simply because I think it's hard to know where, when, and how much this is occurring, and therefore it would be hard to know how those resources could best be allocated. Certainly, DFPR or DEC or some of the other A&R folks could come in. I apologize if I'm slipping into government acronyms, so I can back up, but I feel like maybe you all have a good sense of those ones. We don't want to speak for those agencies per se, and we think they have a better sense of what their needs are. But our sense is that without understanding where things stand overall, it's going to be hard to make strong recommendations in that space. And that's why we think step one is improved and centralized resources. The second piece that we recommend is collaboration among those agencies. So a centralized resource and reporting, but also ensuring that there's no wrong phone number to call, that individuals who think they've experienced timber trespass have a way of getting to the right source for the right solution. And I think there's a lot, this process brought a lot of the stakeholders together, but we can certainly improve and enhance that level of collaboration across the various, I hesitate to call them enforcement bodies because, of course, game wardens don't have authority to enforce timber trespass per se, but we're looking at who's out in the woods, who's able to do the investigation, who's able to help build the cases. So more coordination and collaboration certainly makes sense, as well as tracking both intake and outcome in those cases. And then finally, I'm not sure, Representative Nelson, this response to your earlier question, but more education really is important. And we think, as with the many industries in Vermont, almost all the operators are doing so in good faith and with the right intent and a real interest in ensuring that they're providing quality service or products to Vermonters. We think those are the right advocates to help support people understand and educate overall. And I think that's shared by the VFPA and other stakeholders as well. So those are the recommendations. The last one, and I'm just going in the order of how they were laid out in the Act. Last one is about search and seizure, seizure, falling into other criminal law. Seizure and forfeiture. Seizure and forfeiture as an appropriate tool in this space. More or less across the board, the stakeholders said it's a great idea. And if you imagine going out in the woods to repossess or seize an 11-ton skidder at the end of a logging road, somewhere in Washington County or Orleans County. It's a pretty big endeavor to imagine a local law enforcement agency being able to pull that off, just in terms of logistics and equipment, let alone storage. And then there are issues of joint title on the implement, and the possibility that the amount owed is far less than the $250,000 the machine actually costs, and maybe the bank owns a good portion of it. So there are a lot of challenges there. We'd also just flag that in the event that someone does get a civil judgment against someone operating in this space, there are existing forfeiture and seizure statutes and rules of civil procedure or probate procedure that allow the seizure of property in order to perfect a judgment, get the money. So it didn't seem like the right moment, just given some of those challenges. Again, it would be a pretty big resource lift to get to the point where seizure was an available outcome. So I'll pause there. That's essentially the body of the report. And I'm happy to answer questions or respond to other concerns.
I'm curious about the process, what it looked like to involve stakeholders. Whether you had meetings, one-on-one meetings with stakeholders, whether you got together all as a group. Site visits, it sounded like, was part of it. How long did it all take?
Yeah, it's a great question. I think it began, well, the act took effect, I think, July 1, and I think the first meeting was on the 10th. Emailed outreach correspondence to the stakeholders, asking for asking the questions raised both in the report and some additional follow-up questions from the AG's office. We did an individual stakeholder set of meetings in September, with Megan meeting with individually representatives from each of the stakeholder groups. Hosted a stakeholder meeting in October where everybody came together, where they're able to share their input, responses. Then we circulated a draft of the report in early January. It was actually, to be candid, a fairly short timeline for responding to the report, but we'd laid out most of the different elements and where the report was headed beforehand. Got some input from folks before we submitted the final report. I believe it was the 16th because Monday the 15th was a holiday. So there's a lot of email correspondence back and forth around all of that, and I think a good amount of outreach informally beyond those sort of more specific actions.
Representative Burke.
I'm assuming you had conversations with county foresters in the process.
That's a good question. I'm not through FPR we engaged, but that's a good question. I'm not sure the exact level we talked to county foresters. I'm happy to get that from
Yeah, well, I just it seems like they critical ill. In my mind, I'm thinking off the top of my head, I haven't looked at this bill, but curious to now, of course, but when we hire a builder to do a renovation on somebody's house, you go through a permit process with the town, and you say what you're going to do is the scope of the project, and so at least somebody in town knows what's going on, and then you might describe who's doing the work for you, right? Well, I could see, whether somebody at each town or perhaps the county forester just, here's a general type of contract that we suggest that you have with the logger, right? Mm-hmm. So that, you outline in this contract what you want them to do for you, and they outline what they intend to do for you. But, normal contract, at least that puts like the scope of the project into place. Somebody has some sort of accounting of it to begin with, so I know, I've had loggers on my land, and there's loggers are generally, depending on who it is, but logger I work with is not somebody who likes to do paperwork, but that's kind of what you think when you got hundreds of thousands of dollars of value on your property that you're asking them to handle. There really ought to be a contract involved, some sort of paperwork to outline the scope, and that maybe that's where the county forester gets involved. Mm-hmm. I don't know what their workload is like, or maybe it means adding on an assistant county forester who handles all the, some form of a contract between a logger and a landowner, so that we have a place to start. Because if it's just, they went out and I told them to cut this, but they cut that. Where are you going? How are you gonna keep track of it?
Yeah, I'll get to your hand in just one second. Well,
maybe the bill talks about that. I haven't read it yet.
No, I don't think so. And I don't know that the legislature listed stakeholders that we asked to have included I don't think county foresters were in that group, but it may have also said, and other stakeholders, at your discretion. But it's good. I mean,
What do you think, Jed? This is in your.
Well, there are, to me, pretty obvious stakeholders. I believe Vermont Forest Products Association was listed and participated. The professional logging contractors in Northeast was a second. Did Vermont Woodlands Association, Alan Thompson's the president of that.
I don't believe so. It was-
I thought they represent a lot of landowners. But they should be or should have been. What your point is, and and there was not a consensus among the stakeholders I know that weighed in these various remedies. So some pushed back against notification or trip tickets, for instance. Some supported those, but the piece that the AG's office is recommending, the fourth notion of more education. FPR, by the way, was a stakeholder, and I know they participated. So those were the three main ones. But a contract in Vermont can be written and it can be verbal. There's nothing that requires even a licensed forester to be overseeing the job. There are many loggers that have the capacity, the integrity to manage for all diverse values and goals for a landowner. But the notion of a contract is considered by some organizations to be basic requirement, a written contract or notice is in that. Who the landowner is, what the amount of acres is going to be managed, that includes a map of a delineation of the area to be harvested, perhaps an what the goals are in the harvest. Whether like the one we visited today was really for the primary goal was songbird habitat management. So that's good practice, and with that written document gives all parties, including the foresters involved, but there's a signature of a landowner, a signature of a contractor. There generally require certificates of insurance. So a contract is intelligent and I think offers a lot of obvious documentation support before you ever said.
I think there wasn't a single discussion that we had last year when we were talking about the problem and then looking at bill language and then, ultimately passing it, that didn't involve somebody saying, and we need to include education in, at the end of the day, no matter what we, change with the law, we should be thinking more about education. And that seems to be, we haven't, we're still saying that. So, and maybe we're still trying to answer the question, what does that look like? How is it done most effectively?
And just to conclude what I said, most of the victims of predatory timber theft were targeted by being elderly, often absentee landowners, meaning they might go to south for the winter, and so we're not present. And a predator will rely on I'll do this, I'll do that. I've been doing this my whole life, and we're good. So there nowadays, those are more red flags or orange flags, but there are a lot of rural folks, and the person that's here in our committee now who was a victim, along with most of his neighbors, did not just counted on the goodwill and good intentions of the person who's harvesting, and then they were damaged paddles.
Todd, if we are reading the report, I think Representative Lipsky just mentioned that there may have been, at least may have been instances where the stakeholders didn't agree or couldn't come to a consensus. And the way that we, I think, structured the request for the report may not have allowed for you or required you to report that out. As we're reading the report, will we know if there were places where there wasn't agreement?
I think if not otherwise attributed, so there are certain points in the report that say this group suggested this or this group supported that. I think those are the areas where there wasn't consensus for the most part. The absence of a clear recommendation around a statutory change is also a result of diverse viewpoints. And again, I think our perspective that with the passage of a new law and the need to really collect information, it's a little hard to know what the appropriate next or any appropriate next and additional step might be in this space.
The law just went into effect on July 1st. The report does say that there have been a couple of new cases, at least one in 24 and one in 25. I don't know if they're both since the 1st of July, but recent anyway.
Yeah, and they are not actually land improvement fraud cases. They're broader consumer fraud cases to the point of what appears and what we allege to be a pattern in practice of deception across the board, where similar to the scenario that Rep. Lipsky laid out, continuing in, again, our view and our allegations are to victimize homeowners, landowners by various fraudulent practices. And so there is an element where we would like to see where those cases go in terms of, there are multiple incidents in each of those cases. And so if there's successful results in that litigation, we feel like that could also help change the landscape.
And we all know that the wheels turn slowly, but can you give us a sense of how long it might be before there's resolution?
That's one of the more dangerous questions to ask a lawyer. No. One of the cases was filed very, very recently and is still in the initial, what we call the pleading stage. And so it'll be a bit before that even really gets in front of a judge. The other case, I believe, is in the discovery process. And so there's an exchange of documents and we look to move towards more active litigation in that case. Given the pressures on the court system broadly, it's a little hard to gauge how quickly a case in civil court will.
Right. If there are other questions, and if not, I know we'll be looking forward to getting updates in the future, and if there are other stakeholders interested in sharing their perspective on the process, and we'll be hearing from them as well.
Before we dismiss Assistant Attorney General, there is someone in the room who has been in our witness chair, but isn't on the witness list. I'd like to ask if you would consider, I don't know what the protocol is, if Mike Carabo we could have some testimony or discussion with him before we run out of time.
We don't have a lot of time to do that.
Even 5 minutes.
Mike, were you interested in saying something?
Well, I just heard Todd speaking on behalf of the Attorney General's office, and I'm currently working with the Attorney General's office.
Thank you very much.
Sorry about that. Anyway,
Say your name,
Yes,
for the record, Mike.
pardon me? Mike Caribou, victim number 1.
And Mike, if I'm not familiar with the status of any litigation you're involved with.
So
So
am I.
don't say anything that you're not comfortable saying,
I'm sure this gentleman's probably aware of where we're at with Megan Hariff and David. I can't think of his name right now. Anyway, the Attorney General and I are currently working together on a specific case. And I don't know if I'm allowed to say it or not, but anyway, we are currently working on that particular case. And I was just hearing this gentleman talk about how they're waiting to see how this goes, because what they're going to do is use this as a trial case, I guess, possibly. And what they're talking about mostly now is seizure and forfeiture. Now, they were sworn to the task by the other legislators last year to have provisions or information concerning how other states handle seizure and forfeiture. And I worked with them on a number of states, not work with them, gave them the information that how other states are working on seizure and forfeiture so that they wouldn't have to be looking too hard, because I pointed out what other states currently do. I think it was South Carolina and Georgia and Alaska. So what I'm concerned with now is they're saying they're waiting to see where this goes. Well, so am I, very much so, because they were tasked with a similar thing in 2015 that they never did anything about, neither the Attorney General or the state's attorneys. It's been riding, and since such time that they let it ride, a lot of people that could have been reimbursed for their victimization, there's a time limit. They're no longer included that. One lady was $240,000 because everybody procrastinated and didn't want to do their jobs. A number of other people became victims. And now they're talking about they want to wait or they want to do this or that. Now, I can appreciate that. I wouldn't want them jumping into it. But in the same sense, I question, and a lot of other people that I've talked to, other legislators, just how far people are willing to go on this. And will it be another case of no enforcement because they can't decide which one's going to do it? State's attorney says the AG should do it. AG says the state should do it. So in that case, neither one does it. Now, the only reason that we're here today, and I'm here today as far as H614, is because I couldn't get anybody to listen to me about how this victimization had been going on with this particular family for over 70 years. And now, I'm just trying to think this part out. They say that they're going to enforce the already provisions of H614, and they're going to work on this other provision of seizure and forfeiture. What these other people were saying is that remains to be seen just exactly what they do. They do not have a history of actually enforcing what they've done, and it's been brought to their attention a number of times, and they haven't done it. Now, at the last case, as far as seizure and forfeiture, they said the state of Vermont, in a sense, the AG's office and the Attorney General's office, not Attorney General's, the AG's office and the state's attorney said that they were not versed in seizures and forfeitures and did not really know how to do this, which was not necessarily true, because I'm sure you're all aware that there are a number of different venues where they do seizures and forfeitures. They don't make no bones about that, but they're saying that they're not versed in it. I suggested to the state's attorney last time that if you don't have the information, they referred to the fact that the federal government is the one that does the largest number of seizures and forfeitures. I expressed to them my concern because a number of these logs were stolen. Stolen. It wasn't a breach of contract. They were stolen, and they were taken across state lines and international boundaries. That's what the federal government does. Why don't they turn that over to the feds?
The U.S. Marshals, is that what you're talking about?
Whoever would take care of that, I'm not sure. Whether it would be U.S. Marshals or the federal judiciary or whatever. But that's pretty much it. And I mean, I could delve into a lot of exceptions I took in what he said, but I think the crux of it is we're all concerned to see where it's going. We know where it's been and we knew what was done then. I want to see some results now. And then one more thing, if you're going to have these committees and you want to have testimony, you want to get the hold of the people that have been victimized so that they can show you just what it takes to try to even recoup the money that you've lost or the damage that's been done, the time and suffering, everything, because it adds up. I've been in this almost 7 years.
What I'm going to suggest, Mike, is since you were able to hear the testimony, if you would like to, and you jotted down some notes, it sounds like if you'd like to compile that into a letter to the committee, you can submit that to us. That would be useful for us to have. We are, as I said, we're likely to be taking input from other stakeholders who are part of the process. To be fair, the legislation was passed. It has only been 7 months since it took effect. We asked for a report. We've got the report. The report may not please everyone, but I think that's where we are at the moment. So we will continue to be monitoring the situation. And I appreciate
I appreciate what you're saying too, because you were very much so instrumental to actually getting someone to take the time to actually look what's been going on for years. And I commend you for that.
Mr. Chairman, I would, because we're out of time, I would move that we, as a committee, talk about scheduling stakeholders, other follow-up on this issue that we worked hard on last year. Obviously, not on today's calendar. Thank you.
Yeah, you're welcome, Jeff.
All right, let's take a short break. We have our federal representatives from the federal